Thank you very much to welcome you to Metso African Motives. Today I want us to look at Business Studies Grade 12, Term 1 notes. That is Chapter 1. So, like you remember very well that we did SDA Skills Development Act together in our previous presentation. So today we are going to do Labor Relations Act. So remember, we are still on Chapter 1 where we are talking about the impacts of what of legislation. We are still on the impacts of legislation. So today we're going to look at Labor Relation Act. We are on Labor Relation Act, which is LRA. So we are first going to start with the purpose of labor relations. The purpose of labor relations. So as it says, it provides framework structure for labor relations between employers and employees. So what it means is that the LRA, Labor Relation Act, creates clear rules, creates clear rules for how workers, for how workers for how workers and bosses should treat each other. And bosses should treat each other. Should treat each other. So that is that. It creates clear rules of how workers and bosses should treat each other. For example, the workplace uses LRA rules when they handle disputes by following proper procedures. So that is that. So now let us move on. Let us move on to the second point at where it is it promotes collective bargaining at workplace. It promotes collective bargaining at workplace. So it means that employees can negotiate with employers through trade or trade unions. It means that employees can negotiate with employers through trade unions. Negotiate with employers through trade unions. Through trade unions. Through trade unions. So that is that. So for example, employees can negotiate with employers through trade unions, like we've said. So that is that when you're talking about collective bargaining. So now let us move on to where it says it promotes workplace forums to accommodate employees in decision making. Meaning to say workers can form forums to discuss workplace issues with management. So that's what it means. Workers can form forums. They can form forums. Workers can form a forum to discuss workplace issues with management. For example, the workplace forum discusses changes in working hours before management finalizes it. So hope we get this point clearly. Also establish labor courts and labor appeal of courts. Establishes what? Labor courts and labor appeal of courts. So it means these courts handle serious labor disputes. we are saying these courts handle serious labor disputes. Serious labor disputes. For example, an employee unfairly dismissed takes the case to the court. That is that. So it further on says it promotes simple procedures for the registration of trade unions and employer organization. Meaning we are saying unions and employer groups can be registered easily. We are saying unions and employer groups and employer groups can be registered easily, can be registered easily. So that's what we mean. For example, a new trade union submits the required forms and becomes registered quickly. So that's what this point means. Also, it says provides the right to look out by the employer as a reaction to lengthy strike. So it provides for the right to lock out by the employer during the lengthy strike. So what it means is that if workers strike for long, employers may stop them from entering the workplace. They may be stopped from entering the workplace. So that is that. It also says promotes fair labor practice between employers and employees. So LRA ensures no one is treated unfairly. So we are saying LRA ensures no one is treated unfairly. Is treated unfairly. So that is that. So let us move on to another point. Where it talks about, it clarifies transfer of employment contracts between existing and new employers. Meaning to say, if business is sold, employees' contracts transfer to new owner. So that is that. For example, if a supermarket is sold, all workers keep their jobs under new owner. Then it further on says it advances economic development and justice, labor peace to ensure that the workers maintain the basic rights of employees. So, meaning to say, we are saying it ensures stable workplace that benefit the economy and protect the rights. That's what this point means. Then it also says establishes commission of conciliation, mediation, and arbitration. That's when we're talking about CCMA for dispute resolution. So it means it establishes the CCMA for dispute resolution. We know very well that the CCMA helps to solve disputes quickly and fairly. We know that the CCMA helps to solve disputes quickly and fairly. Quickly and fairly. So that is that. So now let us go to the impact of labor relation on business. Impact of the labor relation on business. So we are first going to talk about the advantages or the positive side. So that is that. So we're going to start with the advantages. As it says, it promotes healthy relationship between employer and employee. So it means, as we are saying, there will be a better relationship. It means better communication, which is going to reduce the conflict in a company. So that is that. It protects the rights of the business in a labor-related issues. So it means, for example, an employer can legally dismiss a worker who commits misconduct. That's why we're saying it protects the rights of the business on labor related issues. So that is that. Labor disputes are settled quicker and are less expensive. So they are less expensive. Meaning, for example, instead of going to court, parties uses what? The CCMA. So that is the cheaper way. Protect employees who embark on unlawful lockouts when negotiations between parties fail. So it protects employees who use lawful lockouts. So, for example, a company refuses entry to striking workers until agreement is reached. That is that. That is always a company is going to refuse the entry for workers until the agreement is reached. So they're going to lock out the workers during the strike. LRA provides for the principles of collective bargaining and puts structures in place with which disputes in the workplace can be settled. So what this means that, as we are saying, we're talking about the collective bargaining, provides principle of collective bargaining. For example, you're saying unions negotiate wages rather than going straight to the strikes. So that is that. Provides specific guidelines for employer on a correct and fair disciplinary procedures. So it provides what guidelines on a fair disciplinary procedures. For example, a company must give warnings before dismissing what a worker. That is that. Employers and employees have a guidelines regarding correct and fair dismissal procedure. So we're talking about provides guidelines for fair dismissal. For example, employees must be given hearing before being dismissed. That is what we're saying. Employers and employees have guidelines regarding the correct and fair dismissal procedure. Employers are entitled to compensation from the labor court if they suffered damages as a result of unprotected strike. So, as we are saying, that it means it provides the mechanism like CCMA bargaining cancels, like bargaining cancels. So we've said it provides mechanisms, sorry, was supposed to be on this point, not this one. Provides mechanisms such as statutory councils and collective bargaining, or CCMA. So what it means is that, for example, as we are saying, it provides mechanisms like CCMA bargaining council. For example, a wage dispute is handled by the bargaining council. So that is that. Employees are entitled to compensation from the labor court if they have suffered damages as a result of unprotected strike. So it means that employers can claim compensation after unprotected strikes. For example, a company applies for damages after workers strike illegally. That's the compensation that we're talking about. Workplace forums can add value to a business if it functions properly. So, for example, workplace forums suggest ideas to improve production. So that is that. So now let us go to the disadvantages now. Disadvantages or negatives of Labor Relation Act. Labor Relation Act. It says productivity may decrease if employees are allowed to participate in the activities of trade unions during work time. So that is that. So, for example, workers take time off for union meetings. So this will make the production to decline. Cost of labor increases because of legal strikes. So we are talking about the labor cost is going to rise due to legal strikes. For example, a long protected strike leads to production delays and financial losses. So that is that. Reduced global competitiveness due to lower productivity. So lower productivity, reduced global competitiveness. So, for example, a factory produce fewer goods during disputes. So this will make it to lose international contracts. That's what it means. Also, the employers may have to disclose information about workplace issues to unions representatives that would be the core of their competitive advantage. So you see now the disclosing information to unions. So that is very dangerous because now the competitors, that information now is going to be spread to other people who can use it for their advantage. That is why we are saying employers must reveal information to unions. For example, a company must show financial reports during wage negotiations. So that's a disadvantage. Employers may not dismiss employees at will, as procedures have to be followed. So a manager must follow procedures before firing anyone. So you don't just fire them at your will. Some business may feel that LRA gives employees too much power as it creates lengthy procedures. Example, consulting with workplace forums. So they are to consult with their representative workplace forums. So that's where we are saying LRA procedures can be long because now they are to do what? They are to consult workplace forums, which is going to delay decision making. So you see. So employers may not get a court interdict to stop a strike. So a court can refuse to stop a strike because it is protected. So you see. Strike actions always result in loss of production, to which employers may not claim. So as you know, workers stop working for days and causing delays now. That's what it means. Some trade unions may not promote the mandate to their members, but embark on the industrial action, which is harmful to labor relations between employer and employees. So some unions may misuse power. So you see, so unions can call strike that members didn't agree with. So that is that. Many employees or employers do not understand and respect the Labor Relations Act. So many workers or employers do not fully understand the act. So a manager breaks a rule because he doesn't know it exists, doesn't know that it exists because of lack of knowledge of the act. So now we are on another point. As it says, labor disputes and bargaining councils process become disruptive, time-consuming, and can lead to decrease in productivity in a business. So a manager sometimes may break a rule because I'm trying to say CCMA process runs for several weeks. As we are saying, labor disputes and bargaining councils become disruptive and time-consuming. So you find that the CCMA process runs for several weeks. So it consumes time. And that can affect our production now. So that is that. Many employees take advantage of the right to strike without acknowledging their responsibility. Some employees misuse the right to strike. So workers strike for issues that are not valid grievances. So that's what it means. So now let us go to the discriminatory according to Labor Relations Act. Discriminatory according to actions according to Labor Relations Act. It says promoting interest of one trade union over others in the workplace is a discrimination. For example, an employer only talks to one union and ignores another. So you see, that is discrimination. Dismissing employees from racial group participated or engaged in an illegal strike action. So we are saying you dismiss employees from one racial group for participating in an illegal strike. So, for example, only black owners are fired after a strike. So that is a discrimination. Allowing only particular gender or age groups to be part of workplace forums. So you allow a certain genders or ages into it in that committee that you're talking about, which is the workplace forums. So, for example, only men are allowed into the forum. So only men are the one who are representing the committee. So it's very unfair. It's a discriminatory according to the Labor Relations Act. Granting leaves to attend union meetings, activities, programs only to site stewards or union representatives. So you are giving leave only to certain union representatives. Only one union stewards get time off for meetings. So that is that. So let us move on to penalties now. Penalties for non-compliance with Labor Relations Act. So penalties, it says the employer may be forced to enter into dispute resolution process. So for example, a company must appear before the CCMA. That is a penalty that you are to face. Business will be fined if they fail to comply with the agreements reached during the dispute resolution processes. So that is that, fined for not complying with the agreements. For example, business ignores a CCMA ruling and gets fined that way. Business that fail to comply with this act may risk financial costs, legal or CCMA fees or fines. So risk legal fees and CCMA costs. So a company pays lawyers because it broke the Labor Relations Act. So now we come to ways in which business can comply with the Labor Relations Act. So it says business must allow employees to form trade unions and participate in union activities as well as legal strikes. So you allow employees to form or join unions. So workers can join, for example, NOMUSA without the punishment. Don't punish them for joining a trade union as an employee. Allow or support the establishment of workplace forums. So meaning to say, for example, management allows workers to create a forum. Employees should not be unfairly or legally dismissed. Avoid unfair dismissal. Avoid unfair dismissal. Employees should not breach or ignore any collective agreement. So meaning to say, you are as an employer respect collective agreements. For example, a company applies the wage increase agreed with unions. Disclose all relevant information required by trade union representatives to do their job effectively. So here, what you're trying to say is that you provide information to union representatives. For example, management shares financial data for negotiations. So that is that. So now we come to the rights of employers and employees according to Labor Relations Act. The rights of employers and employees according to Labor Relations Act. We're going to start with the rights of employers. Let's start with the rights of employers. It says employers have the right to lock out employees who engage in unprotected or illegal strike labor action. So it means employers, what it means is that if employees strike without following the legal procedure, the employer may refuse the entry, so they cannot enter at the workplace, because now the employer has the right to refuse them entry to the workplace. That's what it means. Form employer organization. So it means that employers may join groups that represent their interest in labor matters. That's what it means. Form bargaining council for collective bargaining purposes. So it means that employers can create councils with trade unions to negotiate wages and working conditions. Dismiss employees who engaged in an unprotected strike or misconduct such as intimidation or violence during strike action. So it means that if employees strike illegally or behave violently, the employer may legally dismiss them after fair procedure. He has that right, but he must follow the fair procedure. That is that. A right not to pay an employee who has taken part in a protected strike for service or work they did not usually the strike. So meaning to say, even if the strike is legal, that's what it means. Even if the strike is legal, the employer does not have to pay workers for the days they did not work. That's what it means. So now let us go to the rights of employees. Rights of employees. As it says, employees may join trade union of their choice. Meaning to say, employees are free to become members of any trade union they want. That is that. Request trade unions representative to assist or represent employees in the grievance disciplinary hearing. So what it means is that employees can ask a union representative to attend meetings when they face accusations or lodge complaints. So that is that. Trade union representative may take reasonable time of work with pay to attend trade union duties. So it means that we're talking about what a shop stewards may attend meetings or training related to union work without losing a pay. That's that. Embark on legal strike as a remedy for grievances. So it means employees may strike if they follow required procedure to solve unresolved issues. So that is that. Refer unresolved workplace disputes to CCMA. That is that. So it means that if a dispute cannot be solved internally, employees may take the matter to the CCMA for help. So that is that. Refer unresolved CCMA disputes to the Labor Court of Appeal. The Labor Court of Appeal. So it means that if CCMA cannot resolve the matter or the employee disagrees with the award, they can challenge it in the labor court. So that is that. So this is the end of a presentation on Labor Relation Act. So we are going to go to the next presentation, whereby now we'll be discussing the EEA. That is on the next presentation, but for Labor Relation Act, that is the end of the presentation. Make sure that you are going to share with others. And please don't forget to hit the subscription button. Thank you.